begin, I want to thank everyone for joining us this week. Thank you again for attending our weekly webinar series with Achkar Law. Today's topic will be understanding the human rights application process. We're going to shed the illusion or the mystery behind it and really explain to you exactly what to expect when making a human rights application or receiving one. About us again, we are Achkar Law. We were first founded in 2016. Our focus is on employment law, human rights law, workplace investigation, labor law, and civil litigation. We also have a growing corporate and commercial litigation group. We serve all of Ontario and beyond. In fact, we serve across the country. Today's webinar is hosted by myself. My name is Charles Miller. I'm a senior associate at the firm, and I am joined by my friend and colleague, Madison Shilver. She's also another senior associate here as well. Without further ado, let's dive right in. The question you have is, do I have a human rights issue? How do I file an application? How do I know I have an application? Well, the first thing you do whenever something has happened that has gotten your senses tingling that something may be afoot is to review if you've actually got something under the Human Rights Code that's protected. You see, everyone has human rights. We've got the Charter of Rights and Freedoms, got the Human Rights Code, but the Ontario Human Rights Code process actually templates and provides some boundaries and borders for whether or not a claim can actually be brought forward. The first thing understood is, did you face discrimination or any sort of hurt under a protected ground? The protected grounds are listed on the Ontario Human Rights Commission website. They include anything from age, ancestry, color of your skin, place of origin, if you have your sexual orientation, your own gender, family status, even a criminal record. These are all protected grounds that you mustn't face any discrimination over, but under the Human Rights Code, they only target those grounds under 5 social areas. Those social areas include accommodation, contracts, the forming and drafting of contracts, employment, goods and services, such as going out to a mall and shopping, as well as membership in unions, trades, and professional organizations. So under the Human Rights Code, it protects you from discrimination in those 5 social scenarios. If you face discrimination outside of those, there are other means and legislation for you to seek a remedy. But for the Ontario Rights Code, these are the 5. This is the laundry list of discrimination you must be protected from. Once you've determined that, then the next thing you need to know is, well, can I still bring my claim forward? Under the Ontario Human Rights Code, there is a limitation of only 12 months from the incident, from the last date of incident discrimination you occurred. Under civil claims, it's usually 2 years, but Human Rights Code is 1 year. So meaning that if the last incident occurred 13 months, chances are you won't be able to seek remedy under the Ontario Human Rights Code. That doesn't mean that everything that happened 12 months prior is eliminated. In fact, you can bring that up as part of a larger narrative explaining the discrimination that occurred so long as the last incident happened within 12 months of this application and it's connected to the other ones. It's part of telling your story, part of explaining it. There are special circumstances in which you can bring a claim forward outside of the limitation period, but it's best to speak to a lawyer whether or not you can get around the limitations period, because generally you've determined that you have discrimination on a protected ground within a protected social scenario. It's within 12 months. What do you do next? You made this determination, and now you need to actually tell your story. The best way to do that is to actually gather any supporting evidence to tell a tribunal hearing or tell the Human Rights Commission exactly what happened to you. Now, your testimony alone as an applicant is enough. You just need yourself. You need to be a credible witness. That's all you really need. Keep in mind that your version of events is going to have to go against the respondent's version of events. So let's say you face discrimination within the workplace, which is often what Madison and I deal with. You will have your version, and the employer will have their version. And it comes down to credibility of who they believe. So if you want to have your story carry more weight, or if you want to actually be able to explain it, it's best to have emails, photographs, documents, witness statements, everything in terms of making it very crystal clear that what you're saying is what occurred. And you can answer for any other side of the story. Now, before you file, so you've gathered all your evidence, now you're ready to make an application to file. Before you do so, it is often recommended to first see if you can actually resolve the issue directly or amicably. The reason being is that The application process, just like civil litigation, is onerous. It is difficult. It can be stressful. And sometimes the resolution you're seeking can be just at your fingertips. Employers in the employment setting, as well as if you go out to goods and service industries and you're purchasing something such as a ring for a loved one and you face discrimination, those areas have an active legislative duty to make sure that they have a discrimination-free environment, such that if you go to your employer and say, hey, listen, so-and-so said something against me, say, get the color of my skin or about my sexual orientation, your employer or the manager at some store you were at has a vested interest in resolving this immediately and amicably. So you may find an amicable resolution right away. However, that's all well and good, but sometimes the discrimination that's faced is so harmful that an amicable resolution is just unfeasible. Or even the employer is they're the ones who's actually guilty of it, or they have no means of actually providing a resolution. That's fine. You made an honest effort, and you don't even have to necessarily make an honest effort. The next step is then to file an application. So let's talk a bit about that. You've gathered your evidence, you've determined you've got the jurisdiction. Your first thing to do is now complete the application that's known as a Form 1. These are downloaded from the Ontario Human Rights Commission website. These are smart forms that as you fill them out, they get ready for the next section for you to fill. Make sure you have a good PDF reader on your computer to be able to do so. You can also go and pick up the forms as well and fill them out too. On this application Form 1, this is where you fill the details such as who you are bringing the complaint against, so the respondent, details of the incident. Often there'll be sections within the smart form where you can actually put in the details. We often recommend actually attaching what's known as the Schedule A. So in those sections you say see Schedule A, and then you actually attach another document detailing the narrative, detailing your story of the discrimination experience. And it's good to actually have the details listed, such as who did it, when they did it, what they did, what they said, what evidence you plan on bringing forward. Be mindful that brevity is very important. The HRTO specifies that they only want these to be about 5 pages, which means that even if you've got years of dirt on what happened to you or on the other person, you need to be very brief about it, straightforward, just to the point, so that you can tell your narrative very quickly. Within this Form 1, you're also going to have the remedy you're seeking. You might be seeking monetary damages for the injury to dignity. You may also be experiencing lost wages if this occurred in the workplace, so you lost your work as a result of the discrimination. You can even submit progressive remedies such as ensuring that the area or the protected ground you face as discrimination has to adapt a new policy for preventing discrimination in that area, or for new training initiatives within that area as well to make sure that that discrimination doesn't happen again. These applications, once you've filled them all out, either on your own or with the assistance of a lawyer or a support person, can be submitted online, which is the easiest, by mail, or in person at the HRTO directly. Here's where things get a little frustrating. Once the HRTO receives your application, they will acknowledge receipt. This can take several months. You heard me right, months. This is because the HRTO has a significant backlog and not enough people to help go through all their applications. Ever since COVID-19, they experienced a severe backlog. They lost many of their people they needed, and they've been trying to rehire new people to get through this backlog. The HRTO is very far delayed, so it can be several months before they even acknowledge receipt of your application. And that's before they then determine if they have jurisdiction to hear it. They'll acknowledge they've received it, and now they need to determine if they have jurisdiction, which is fine if you filled out Form 1 correctly and you've determined that this is a protected ground and this is an area this is a social area that's protected. You can feel comfortable that it will be accepted. Once the HRTO has determined that their application is good to go forward, they will then inform the respondent that they have 35 days, that this is their application that was issued against them, and they now have 35 days to file a response or a Form 2, also downloaded by the website. So if you are somebody who has received a Form 1 or an application, review it, speak to a lawyer. You can actually go to the website, download the Form 2, and then tell your version of events. Explain things from your side of the story and your own narrative. 35 days is not a lot of time to gather the evidence of something that could have occurred 6 or 7 months ago. So you can email the HRTO registrar to ask for an extension. In our experience, these are usually granted, unless there's any reason why your extension request is just silly. But generally speaking, most of these extension requests are granted. You'll have a bit more time to actually draft and file your response. A response has been filed, and it will take another several months for the HRTO to acknowledge receipt of the response and then provide that response to the applicant. Once the applicant has received a response, they don't have to do anything about it. In fact, the HRTO will move forward to the next stage, but sometimes the response to the application may contain new information or provide a different version of events that, as the applicant, you just feel the need to clarify. Especially to bring up new information that is completely redundant. As an applicant, you do have the ability to file what's known as a reply. That's a Form 3, and that is a reply to the response to clarify the issues. But you don't have to file. It's not necessary. You may also receive what's known as a Form 10. This is a request to order. Either side can submit a Form 10. These are asking for more documents, asking for explanation, but sometimes a Form 10 is the respondent saying that the application is stricken or should be delayed or stayed. Often this is because there's another active process ongoing and they don't think there should be two concurrent ones, or there's some other reason why the application should be stricken altogether, in which case, as the applicant, must file a Form 11 or a response to the request to address why this order should not be agreed to or why it should be agreed to in part. And as I said before, reply is not necessary, but a response to request is. We've now gone through Form 1, 2, and 3. Those have all been submitted. The next stage is typically mediation. And to talk about that in more detail and walk you all through it, I want to tee it off to my friend Madison, who's going to talk to us exactly about what mediation looks like at the tribunal and what the hearing process will look like as well. Take it away, Madison.
Thanks, Charlie. So after you have submitted your application, you've received a response and submitted a reply, call that the pleading stage. Once that's closed, then the Human Rights Tribunal will offer mediation dates. As Charlie had mentioned previously as well, this can be quite slow. There is quite a backlog. Getting a mediation date can take a couple of months. Now, in the Form 1 application and Form 2 response, you actually get to list if you would like to participate in mediation. A lot of times we will recommend that you participate in mediation. It's a really good tool to try to come to a resolution a little quicker, because the trend with the tribunal, because of the backlog, is that it does take time to graduate from one step to the next. At mediation, if anybody's ever gone to mediation, usually both parties will attend and there'll be a mediator. You'll generally be put into what's called breakout rooms. A lot of these are held via Zoom now after COVID-19. And you're put into separate breakout rooms, and the mediator just jumps from room to room. And during mediation, this is, again, voluntary. You can opt into it or out. And it's confidential, meaning any offers exchanged, any information you share is not going to be used at a hearing if mediation is unsuccessful. The reason behind this is so that parties can be open and can negotiate and not fear that if they say something in mediation, it's going to affect what may happen at trial. And therefore, hopefully, mediation is more transparent and successful. If mediation is not successful, the mediator will notify the tribunal that the parties did not come to a settlement, and they will put your matter in the queue to get a merits hearing date. So what happens at the merits hearing? So you're going to go to mediation, and unfortunately, if you're not successful, the mediator is going to notify the tribunal, and the tribunal is then going to send the parties at some point either a notice or confirmation of hearing. The notice and or confirmation of hearing is a letter. It looks like a letter, and it's going to detail the specific steps and deadlines that each party need to complete before the merits hearing. Typically, and this can vary depending on matters, some matters are a little more complex than others and might have other moving parts. But generally speaking, there's a deadline where both parties put forward a witness list, and they put forward a list of arguably relevant documents. These are just the documents you're proposing to the Human Rights Tribunal that will be included. Then there'll be a second date where you put forward your witness statements, as well as the final list of documents that you're going to be relying on. So this is going to be all the evidence that you're going to be relying on during the merits hearing. So it's very important that you record these deadlines and you don't miss them. The tribunal can be very unforgiving. Similar to any deadline, you can ask for an extension if you need it. The tribunal generally awards them as long as they're within reason. So if you need an extra week or two, tribunal's likely to award you that extra week or two to submit your witness statements and or list of documents. You can also talk to the other party because they may be going through similar situation as trying to gather all of their witness statements and documents, and they may need an extension as well. And then you could ask extension on consent. One last thing to mention about this is you can also include expert witnesses at this stage. Depending on what the matter is, generally we see a lot of expert witnesses come in disability matters, so discrimination on disability. They might have a doctor come in and speak to it, do a report. You'd have to submit a witness report prior to, or an expert report prior to the hearing, and that would be included in those deadlines as well. Last point I'll say about all of this is if you do have any questions and you are a self-represented litigant, the tribunal is very user-friendly. They have a great hotline. So if you find yourself in this stage and you're not sure what needs to be done, how it needs to be done, there is a really great hotline through the tribunal website that you can call, and they'll help you through some of these procedural issues. It's not legal advice, but some of the procedural issues. So this is like a really great tool to use if you are a self-represented litigant. And in this letter, so the letter will actually list the hearing date and then all these deadlines, and then you just attend the hearing. Generally speaking, since COVID, a lot of these have been done via Zoom or teleconference. I do believe they are starting to bring some in person. On the website, it still lists that most of them are done either via video or teleconference. You would attend the day of, and during that day, you would want to prepare opening statements, closing statements. You would want to make sure you have your case law research done prior to going in. You would want to have examination questions, so questions that you're going to ask their witnesses because you're going to get those witness statements the same time you deliver your witness statements. So there's a lot of prep work that goes into that day of hearing, and really what you'll want to do is make sure you have all your questions ready if you're self-represented, have your case law put together that you're going to include in your closing statement, and you have the questions you want to ask the other party about their witness statement, their version of events, or if you want to get them to admit to something that would help prove your case. You can either do this on your own or through a lawyer, hiring a lawyer if you can afford one. This can be a slightly complex process. The main format of a hearing would be opening statements. So both parties would give their opening statements. The applicant would then, depending if you're self-represented or you have a lawyer, they would have what we call direct questions. So if I was the lawyer of the applicant, I would then take my client's witness statement and just ask them some questions if I wanted to clarify some points. And then the respondent's lawyer would have a chance to question the applicant on their evidence. So that would include the witness statement that the applicant would submit, as well as the list of documents. And then it would, depending on, again, how many witnesses, if I'm the applicant's lawyer and I have another witness, I would do the exact same process, direct questioning, and then the respondent would have a chance to question that other witness. And then it switches. The respondent would then put forward their witnesses and they would have their direct questions. And then I, as the lawyer for the applicant, would do cross-exam questions. And then at the end of the hearing, we would do closing statements where we kind of bring in all the evidence, we talk about the case law, and we try to justify the damages and tell the tribunal why they should find or should not find discrimination, depending if you are for the respondent or the applicant. And then at that point, you would leave. Most times you won't get a decision same day. The adjudicator may take some time. They'll end it and say they're going to deliver their decision in due course. This can take, again, a couple of months. All of this process, I'd say, I like to think of the tribunal process as rolling hills. You're going to start with the application, and then you're waiting for the response. And then the response comes in, so you have the reply, and then you're waiting for mediation. And it's like rolling hills, unfortunately. It's very hot, and then it's very cold. And so this can take a couple of months as well. And in the decision, they're either going to grant your remedies if you're the applicant, or they're not. And remedies that can be granted from the Human Rights Tribunal are monetary. Obviously, you could get the damages for the pain and suffering as a result of the discrimination. You can also get damages for lost wages. Again, this is more on the employment side of things, the wages you lost due to the discrimination. If you were injured, whether at work or maybe on the premise of if you were injured at work and you lost out on wages there, you could get those. You could get physiotherapy. You had to go get physiotherapy and that wasn't covered. You could try to claim that. So those are all kind of captured under special damages. And then there's policy changes. You can also request not just monetary. You can ask that this company instill training, new policies, posting of the human rights code, and depending on the circumstances, because it really does vary case by case, but in short, you can get some policy changes and they can do that. There is few cases too where you could try to get reinstated. The tribunal does have the jurisdiction to try and reinstate, but most people don't want to return to a place where they've been discriminated against. And then I just kind of wanted to recap some of the key forms here that we went over. So obviously the Form 1 application, that's one of the most important documents in your litigation. It kind of sets the foundation of the whole litigation. The response is then, the respondent's chance to tell their version of events and why there's no discrimination. The reply is not mandatory, depending on what's contained in the Form 2. It may not require Form 3. And then last, I just wanted to quickly talk about Form 23. So this is a statement of delivery. It's similar to an affidavit of service. There are certain documents when you serve, you do have to serve it with this Form 23. The reply, if you do serve it, has to be served with the Form 23. And it will tell you when you do receive the Form 2 response, there's a letter that comes with it, and the tribunal will tell you what you would need to do if you are going to be filing a reply.
All right. Thank you so much for that, Madison. We're now going to put Madison on the hot seat while she answers all of your questions that you've submitted. We've got a few here. I'm going to start with the first one. So Madison, this question here has two parts. So the first part is, if you have been fired on the grounds of disability because you were injured at work and you can't do your regular job and modified duties were not offered, can you request your job back as one of the remedies once you've had surgery, healing, you get better?
Yeah, so like I said, the tribunal does have the jurisdiction to order reinstatement. It's fairly uncommon, just based on my review of the case law and experience, but that is something you can ask for, is to be reinstated if you were terminated on the basis of disability.
And one of the follow-up questions here is, what should you do if you have witnesses with crucial information, but they are refusing to participate because their fear of losing their job or any sort of reprisal against them? What can you do with those witnesses?
So that would come in at later stages. Usually once we get to that hearing stage, there's actually a summons to witness form on the HRTO website. So if you have a witness that's not being cooperative, you could issue a summons to witness to force them to attend the hearing. I would say it's a bit of a double-edged sword trying to force a witness that doesn't want to be there to a hearing, just because you don't know how favorable they're going to be to you. Obviously, if you have a willing witness, the evidence they're going to give is going to be more favorable versus a witness that's maybe doesn't want to be there. So that's just one. It's a hard balancing act there.
Absolutely. And, as you mentioned before, your testimony alone is enough. It comes down to credibility. And if you have to force someone to be there, as Madison said, chances are they're not very. Here's another question that was submitted earlier. Madison, on what grounds can I, as a respondent, have an application dismissed before a hearing? I think they're talking about what can they use a Form 10 for.
Yeah. So that would really depend what's inside the Form 1. So if there's no ground or it's outside the jurisdiction, so not one of the 5 social areas, they don't have enough to show discrimination. There are some situations, I'm just going to base it on employment because that's where most of my experience lies, is where the connection between what they think the discrimination is and the events is very remote. That could lead to there not being enough of a substantial connection. One of the main tests with the Human Rights Tribunal is that it has to be more than, sorry, the words are eluding me right now. It has to be more than minimal. It can't just be because it's unfair. They don't make decisions on unfairness. That's another point. I don't know, Charlie, can you think of any other of those off the top of my head?
Yeah, one of the other ones is concurrent jurisdiction. So if you hire in the employment context, let's say you have a union and the union's already dealing with the discrimination issue, well, then you may have a stay of proceedings with the Human Rights Tribunal, or while the OLRB or the union is dealing with the discriminatory grounds of it. Or if, for whatever reason, there was a settlement prior that wasn't brought up in the application, if this matter has already been resolved, the Form 10 might be applicable as well. Thank you. So, Madison, this one goes straight to limitations period. What should I do if I just found out I wasn't hired for a job on discriminatory grounds for a job I applied for 3 years ago? I just learned through a friend that the reason I wasn't hired is because the store owner did not think a woman should work in a warehouse. They just found out.
That's a little tricky. One thing I'll say is evidence-wise, that could be tricky to bring. I mean, if we go off of the principles of discoverability, when it comes to limitation periods, if you just discovered it now, you may be able to make a pretty good argument to the Human Rights Tribunal that you weren't aware of the claim, even though you didn't get the job. And then just another risk to that could potentially be like, how could you prove it? But you could argue, like I said, on the doctrine of discoverability that you did discover the claim till now you didn't know you were not given the job due to discrimination. So that may be one way the tribunal may allow it to pass that 12-month mark.
Very good. Another one here is if I have to hire a lawyer to defend myself at the HRTO, can I recover those legal fees?
No. So the Human Rights Tribunal does not award legal fees. However, you can negotiate for them. But I mean, I guess if you're defending, probably going to be hard to negotiate it for because you're going to be the one having to pay if you want to settle. But if you are successful at the end of the tribunal, you would not be able to recover those legal fees, unfortunately.
Right. This is why when we have respondent clients on our behalf, we do try to advocate for an early resolution as fast as possible because legal fees are not recoverable, even for complete nuisance claims.
Mm-hmm.
So we've got time for one more question here that I have. So Madison, what if I complain to HR about sexual harassment, but they don't really do anything about it? Can I still bring an application forward even though I went through a resolution process?
If you went through the resolution process and you feel like it wasn't properly addressed, feel like you were brushed aside, and then you're put back in the same environment as your harasser, then yes, that would be discrimination and failure to accommodate because they haven't dealt it. I don't know if there was an investigation, but if there is issues of sexual harassment, generally I would look to see the employer investigating it. If they didn't investigate it, I would argue that they handled it inappropriately. So yes, even if you went to HR and they failed to address it, that actually strengthens your human rights claim because you brought it to the employer's attention. If you don't bring something to their attention, how do they know to address something? So yeah, you definitely still have an opportunity to file a human rights complaint.
Perfect. And to build off a bit of what Madison said there, whenever there is an employer or any sort of respondent, there are two sides or 2 points to consider. One is what was the discriminatory conduct that occurred? And the second one is how did the respondent deal with it when they learned of the discriminatory conduct? If you're an employer and you have found out that one of your employees, let's say a supervisor, was inappropriate or discriminatory to another employee, and you didn't find out about it, chances are the human rights should be a little more understanding towards the larger employer for having no opportunity to come in and remedy the situation immediately. However, as Madison said, if the employer did learn about it and did make efforts to remedy, but they did a poor job of it, damages could be substantial. So if you are a respondent, please do contact the lawyer. So that is all for our question and answer period. Madison, thank you so much for taking the hot seat there. Everyone, thank you so much for attending today. That is our contact information appearing on the screen. If you are a potential applicant, respondent, please do contact us. We would love nothing more than to walk you through the process or to help you address concerns that come our way or come your way. And again, thank you for attending today, and we'll see you all next week. Have a wonderful afternoon.
Bye, everyone.